This is Alan Gassman, and welcome to this presentation on estate planning for Latin American families. I'm here with a lawyer who I have known for several years and who I have worked with on a number of occasions. He's very bright and he's very, very responsible. His name is Luis Silva, and Luis has a political science degree from the University of South Florida in Tampa, Florida. And then he has his law degree from West Virginia University and a master's degree, a post-law master's degree in tax degree called an LLM from the University of Florida. And Luis has extensive knowledge and experience in Latin American estate planning and business law. So I've asked him to join us to enlighten us on what we need to know as US-based estate planners when we get Latin American clients, and what Latin American clients need to know about planning on the Latin American side of things. So, Luis, welcome, and I won't be saying much more.
All right, thanks, Alan. So I'm gonna go ahead and just kind of get started here. Give me one second while I get this worked out. And Alan, can you see my screen, the presentation?
I sure can.
Okay, great. All right. So as Alan said, my name is Luis Silva. I'm actually originally from Peru. I have some experience, obviously, with Latin American families, including my own, and I find this entire field fascinating. It's also fun seeing the cultures kind of mixed together. I'm with Leach Tishman. We're a full service law firm based out of Pittsburgh with offices in Florida, New York, California, and a couple different places. So just to get started, one of the first things that we need to talk about, the big elephant in the room, if you will, is going to be the cultural differences between Latin America and the United States. Again, something I've experienced just firsthand. I remember family ties, just in case most of you are probably familiar, but family ties in Latin America are more, I don't want to say they're different, but they are in a way that our families can be a little more, let's call it, I don't want us to use the word intrusive, but they can be very involved in our lives, right? Uh, there's a lot less personal space, if you will. Along those lines, in Latin America, it's not uncommon to have a multi-generational housing where it's grandma, grandpa, and then the parents living there, and then the kids just either adding on a floor or that's not an uncommon scenario. uh, Beliefs around estate planning, and this is one I've faced on my own. My parents are growing up, they would never talk about planning or any kind of will structure because of the belief that then you're inviting death, right? The idea being that those that plan out their estate are getting ready for the next life. They're right on the cusp of that. Along with that, obviously, speaking about death in general is taboo, and obviously that brings in the estate planning part of it, right? So it's one of these scenarios where you kind of have to not just begin the conversation with, this is something that we need to do to address different aspects, but also try and introduce it in a way that makes sense to everybody. We're doing this to avoid any future issues is one of the things that I found that works with clients. And just making sure that you think through different scenarios, that kind of thing. That said, intestacy, as you can imagine, is not just the norm, but is very, very prevalent. I actually recently listened to a CLE type, just a kind of a talk by a Peruvian a professor at the University of, the Pontifical Catholic University of Peru, and he was saying that generally, not 1%, but actually less than 1% of all individuals have a will. Most everything is passed through intestate. So let's go through some of the vocabulary words, and obviously this goes back and forth. There's one thing is to know conversational Spanish, which I grew up with, and probably a lot of you are familiar with. And then the other aspect of it is getting into the legal terms, right? So things such as estate planning, for example, right? Planificación patrimonial. That's very, to get everybody on the same terms is key. Will, testamento, testate, and intestate. Those actually don't go. Those don't switch too much. Probate. It does have two different terms depending on whether or not it's an intestate estate or a testate estate. And this kind of makes sense, obviously, also from the U.S. side of it, where, if you have a will, you're trying to bring that will into probate, admit it, make it legal, if you will, right? So that's legalización. And then sucesión is for an intestate estate where there's just a succession. Trust, that's fideicomiso, right? And here we get a fun word, trustee, fideicomisario, right? The trustee, that would be that term. Decedent, generally in the law, they're referred to as the causante, as in the person that caused the estate to be open, the administration to start. And then I threw this one in there because we are in Florida, and homestead, right? The hogar would be just home, principal, but in generally, real property is referred to as an immovable, right? Un inmueble. So moving right along, let's go ahead and kind of talk about where this would ultimately all play out, right? You have legal systems in Latin America that are obviously based on civil law, and that's different than what we're used to. Generally, it does vary from country to country. Obviously, even in the U.S., you go from one state to another, and you're going to find differences. Probate actions generally take place in the decedent's place of residence, or where their property lies. Again, that's similar to what it is here. One thing to note, though, is generally once you're in country, you don't have to go do an in rem proceeding or an ancillary proceeding in the different parts of the country as you would here. Generally, once you're in the system, that judge, that whoever is presiding over that proceeding can take care of all the property within the country. Generally, outcomes in intestacy are similar to the United States. That's nice because we can transpose some of our knowledge there. There are some key differences, as I will discuss with spouses and other people like that. It's actually they've taken a different approach, and it's quite interesting. Then obviously the civil code system gives us powerful notaries, right? That's something that I think we need to communicate to our clients and actually also understand that notaries are basically quasi judges in the civil code system. Then obviously there's a bureaucracy that's involved in a lot of these places. You have to talk to one person who may be out at lunch, who isn't in, and that can cause some delays. And once we get into the judicial caseload, that's obviously, again, same kind of scenario where you're relying on these individuals and they may not be available for a quick proceeding. So as far as the probate process and the will admission, it will depend on the type of the will, right? Generally, you have a couple different types of wills. The holographic will, which is kind of what we have here. Again, somebody just writes their will out, they sign it, and they seal it. They give it to a notary, or they have it somewhere, and then that will tries to get it, gets admitted into the probate system. You also have just your common will, which would be kind of what we have here, where it's drawn out. You have the document typed out, and then two witnesses, obviously the person making the will, the testator, would sign that with the two witnesses and then have the notary. The key difference between here and there is that you can actually have that will admitted into the public record right away, not necessarily the contents of what's in the will, but that there is a will present. That obviously avoids any issues in the future about getting this thing admitted and kind of speeds up the process. And then finally, you can also have a will where you can dictate to the notary what you want, and the notary will register that, and they'll list it as a will. Now, again, There's notaries, as I mentioned, they may be used generally for the whole process, the entire probate process in Latin America. That's, again, one of the big differences. In uncontested actions, a notary can actually take care of the entire process. Once things become contested, then you have to go into judicial intervention. And finally, depending on your jurisdiction, some debts can also be transferred into the heirs, right? So you inherit debts as well as assets, which is not something that occurs in this country generally. Just as a quick overview, right? U.S. legal system, laws vary from state to state. Generally, all probate actions require some kind of court action system. Attorneys necessary to start an estate. Probate actions, just like in Latin America, must take place in the place of residence or where the property lies. We talked about ancillary administrations. I think, this being one of the key differences between our system and then what you find in Latin America, I think it's important to tell your clients right away that, if they have a piece of property or if they're Florida residents and they have a piece of property in Pennsylvania and, they don't set up any kind of trust or some other type of vehicle, then they're going to have to go starting ancillary action in that particular state. And again, this is something that may be new to them, communicate that and just give that expectation. Then again, uncontested actions where we like to be fairly efficient. Although, if there's an estate tax issue, it's definitely going to take longer than a year. But, most states will resolve within a year if they're uncontested. Again, debts generally die with the decedent. Again, we've already touched on this, but remember that your client, a Latin American client, is going to have a different notion of what a notary is and what they do and what their powers are, as opposed to wherever they may have immigrated from or whatever knowledge of that legal system they have. What I like to tell my clients is that a notary is kind of a super witness, right? And that shocks a lot of them. But once we have that understanding, they come around and we're all on the same page. Remember, this is all about communication and just those vocabulary words and getting everybody again on the same page is key. Next, so planning considerations, right? So here's kind of the big kind of an overview of what you need to communicate to them. Life planning documents, right? Your power of attorney, your living will, your healthcare surrogate. They may have some documents from those countries, where they may have had some kind of contact with. A lot of Latin American countries now, I believe Chile, Peru is working on one, and I think Colombia also have right to die provisions. So there's the dignified death, that kind of planning, that kind of process in the works. Obviously, here in the United States, it's going to vary from state to state, but just know that there's also some clash, right? In a lot of Latin America, we have Catholicism baked into our legal system and into the country, right? The difference between the line between state and church doesn't exist. So you want to plan for that and make sure that they know that there's you have to have documents for here and maybe documents for there. And obviously when you're dealing with documents from wherever they may be, wherever they're spending the time, it's always great. It's always, you have to contact local counsel, make sure everything's up to date there. Again, with that thing we touched on earlier, wills, obviously not just for those later in life. One word on foreign wills. For example, in the state of Florida, most foreign wills can be admitted into probate as long as they meet the criteria of that jurisdiction. One caveat of that, right, is that notarial wills, that last one I talked about, where the dying person or the person called or the testator brings in a notary and dictates their will to them, and then has the notary sign that as a true copy of their will or their true intent. That's actually specifically forbidden here in Florida. So that document that what may be good in wherever is not good here. And obviously having the client understand that they may have to redo their document. Obviously, if they're going to be full-time U.S. residents, they definitely should. But if having any piece of property here, they wanted to align with the rest of their estate plan, you want to make sure they consider all these things. That said, Most of the other types of wills, or the other types of wills rather, just generally would meet admission standards here. They require 2 witnesses and a notary to have the valid will, and that's good enough for us. Then definitely holographic wills, as I mentioned, are also a type of will that they're prevalent in Latin America, and those would be accepted generally here as well. You know, the other thing that we have to look at are limitations on transfers, right? So obviously in the United States, general minor children and spouses are protected classes. You can't write them out of your will entirely, and there's similar provisions in Latin America. However, I mean, as far as, for example, in Peru, there's a constitutional right to free disposition of goods. So, you don't have anything really tying you outside of obviously your obligations to your minor children. Then, we would, next thing to look at is actually trust. So trusts are prevalent all over Latin America, but one of the key differences, or one of the things that we have to look at, is whether or not that entity is going to be recognized as something that can hold property or any other kind of good. For example, Colombia is one of these is a country that does not recognize a simple trust as an entity that can hold property. So you may think that your planning's all done. You stuck that Pennsylvania, you stuck that Colombian condo or house or whatever it is into the revocable trust, and you're thinking that that's fine, that you don't have to worry about it, only to find out later that it's not. That's not a valid transfer under Colombian law. So we want to verify that those trusts can legally hold title, and then maybe consider a more developed estate plan. If you want to go ahead and make this thing global, right? You have to jump through, or you have to make sure that the entity you're creating is valid in all these other places, so that you serve your client well, and it provides the level of the planning that they're expecting. Here's one key word, right? Cohabitation. This is something that's not uncommon in Latin America. Some Latin American countries, Peru, for example, they recognize long-term relationships where people are living together to form a type of common law marriage almost. And what you do is basically this person is treated as a spouse under intestacy, and they're given all those same rights. This may be intentional, not intentional, and you do have to jump through some hoops. For example, again, in Peru, if say you're living with your girlfriend for 2 years as husband and wife, then you pass, that person, right, the girlfriend in this case, would have to go declare or get a declaration that they were living, they were cohabiting, and that they get a civil certificate, and then that person would be able to go into the courts and exercise the right under the intestacy statute. Obviously, we can avoid all this if we have the testator just draw up a will, but that's an interesting tidbit that we don't have here in Florida, as we don't recognize common law marriages. Debts, again, communicate to your clients, and I've had to do this a few times actually over the years, where the client or the heirs do not want to start an estate proceeding because they're afraid that all these the debtor, all the creditors are going to come after them as debtors. Obviously, just explain to them the process, that probate is you take all the goods, you take all the debts, and you kind of net them out, unless they're specifically protected assets. And a great example of that's here in Florida, right, with homestead. And homestead is that big piece that you have to communicate to your clients. I mean, that's not just hard for people in Latin America to understand our concept of Florida homestead, but even people from other states. Then obviously the big piece of this is potential tax issues, right? You have the estate tax that is levied on all U.S. property of non-U.S. residents. There is no active tax treaty with any Latin American country that I'm aware of. So you're going to be running into this issue, right? The exemption is $60,000 for non-U.S. persons, non-U.S. residents. So let's say that your client bought a piece of Miami real estate or Tampa real estate in the 90s, all right, and that thing is appreciated now. They have a U.S. estate of $500,000. Obviously, this exemption is not going to cover them, and they're going to be facing a kind of an estate tax issue here, a heavy one at that. On the side of U.S. residents and U.S. citizens, make sure that, well, not just as for income tax purposes, but for estate tax purposes, our laws encompass worldwide income and worldwide assets. So if you own a piece of property in, Mexico, Colombia, Peru, Brazil, wherever it may be, that is taken into account as to the size of your estate. The other piece to kind of look at is our income tax issues, right? We don't have an inheritance tax here in Florida. We don't have a state-based income tax, but or I'm sorry, a state-based income tax or estate tax. But in certain countries, this is the case where you inherit something and it's not necessarily seen as an inheritance, and there's no specific inheritance tax, but it's treated as a long-term capital gain, and that's the kind of tax that's triggered. That's the case in Colombia. Brazil has its own inheritance tax, and that's something that you have to grapple with too. Make sure that you're going to have funds to pay off all these taxes if you're going to take property in kind. So let's see. So after that is just make sure that not just with the inheritance tax issues, but remember trust, right? They're entities we form, and they may be subject to just all kinds of income and other transfer taxes at the local country level. Finally, remember, important to check with local counsel. All right, tax laws are complicated enough for us U.S.-based practitioners to knowing every jurisdiction in the U.S. When you're talking about different countries, different practices, you're going to need some backup there. All right, so this is actually the conclusion here of my presentation. Generally, takeaways are the legal systems as relate to probate and estate planning in general are similar. There's obviously there's a lot of different pieces to look at, but generally remember that you talk to your clients in a way that they understand what they're getting themselves into, and make sure that they also know to share everything with you, because that piece of property in Colombia that they think is covered under their U.S. will may not be, or they may have put that piece of property in, again, in a trust or some other kind of vehicle that they thought would cover them, but at the end of the day doesn't. Key takeaway here too is that the U.S. process is generally faster, as we do have our occasional delays, but generally things tend to move along. Remember, when you're talking about non-U.S. assets and non-U.S. courts, the expectation there is going to be that there may be more of a delay. So if you have somebody that has family here and again with property outside of the country, make sure they're aware of that extended time that may occur, right? So just give them a heads up that you may be dealing with this for a couple years. And then finally, again, I've already said this, but I'll say it again. Succession planning has to take into account all the laws and other factors that that person has contact with, because once again, communication is key, and getting your client to you understanding your client is going to be the first and best thing to do here. So that's my presentation. I don't know, Alan, if you have any questions or any comments, I'll be happy to take those.
I apologize there, I was muted. So, Luis, what do you specifically say to a client who may be fearful that talking about death or planning for death would expedite their death? What specifically do you say in that conversation?
Well, I try and, you kind of have to use a combination of not just, your interpersonal skills, but also let them know that it's better to, one, that that's not going to be the case. I have a will. I'm still around. We have tons of clients who have this. They're also in the same boat. But I think more than that, it's a just letting them know that you're planning to avoid any future issues, right? Because you may have you have 5 kids, and you don't want them fighting. You want the family to continue. It's We all want, at the end of the day, I think, the same things, right? Here or there or wherever. We want family unity. We want to make this tough time as easy as possible for everyone. And I think just giving clarity and having a good estate plan is definitely it's key there. And conveying that to clients and getting them to understand that is, I think, is the best way to go about it. That's the best tool I found so far. If you have any suggestions, I'll be more than happy to take them. But it's just getting through to the client that we're planning so you don't have issues, so that Susie doesn't fight with Juan here. Okay, we want to make sure everything's clear.
So when I'm working with a client here in the United States and they have family in a country in South or Central America, and I want to make sure that their parents' estate plan is done right, or I want to make sure they have a will that's compliant in that country to handle their real estate in that country. Am I looking for a notaire? Am I
Uh,
looking for a lawyer? What am I looking for?
Sure. I mean, notario, right, is generally notarios, right? Notaries have to be lawyers. So you're a notary or you're a lawyer first, and then you can become a notary. So it's one of these where generally, right, why does this term carry so much weight is because not just any attorney can be a notary. There's like a long process. You're selected. You're one of these key government people, kind of a leader in your community almost. So yeah, so if a notary drafted up your will, that's great. It's you just want to make sure that one, that they have a will that's valid. If they have property here, that's valid here. Because again, if you have one of these wills where the person simply, it was an oral will given to a notary to write down, that's not something that's gonna fly here, right?
So a holographic will, I'm trying to remember, that's a will that's handwritten without
Correct.
witness to notaries, and those will stand up in many of the countries.
Right. A lot of them, I mean, you're talking, depending on where the population centers are, right? You may be somewhere where you're nowhere near an attorney, right? You can't find one. So that's where a lot of this thinking is. Yes, you can write as long as it's in your own handwriting and you sign the bottom of it. And again, there's a date. That's actually that's one of the key factors here. Is you have to have a date on the thing. Then that can get admitted. That's taken as a valid will in a lot of Latin American countries.
So if you own real estate in a Latin American country or you have a business, at least my experience in Costa Rica has been that you would form a limitada, which is similar to an LLC and may be disregarded for US tax purposes as long as it checks the box right. Or you may form an SA, which would be treated like a C corporation. Can you give us just a little bit of discussion of corporate law in Central
Sure.
America so we know how it works?
Sure. So there's all kinds of associations, right? You have, and again, these vary by country, but you can have an anonymous society, right? Sounds a lot more mischievous than it actually is. That's just irregular. Just it's treated as a C corp. There's actually a whole list of what entities are denominated as what what type of U.S. equivalent that I believe the IRS puts out. So you can always look to that list, and then see what kind of impact that's going to have on the individuals in country, right? Because if I don't know, you're in Costa Rica, you're in Peru, you're in El Salvador, you trying to plan, you have to obviously take into consideration what your overall goals are and see where you're going to land if you choose, again, an SA, as opposed to just a regular sociedad, right? A regular partnership. How is that going to impact stuff? And see what kinds of vehicles are available for you and for your family there.
Right. Okay, here's a question from Rebecca. What about a green card holder, whether permanent or conditional? Do they have marital deduction if married to a U.S. citizen?
So generally, yes. So it's there's no right in U.S. income tax law. We have the 183-day rule, whether to decide whether or not you're a U.S. tax resident. The estate tax is a little more fuzzy. It's that can be taken into account, but I mean the fact that you have a green card, and then I'm not sure if they're talking about themselves or their spouse, but you would be a U.S. person at that point if your intent is to permanently reside in the United States. Then you are a U.S. person, not just for immigration purposes, but obviously for tax purposes. But there's you have to have kind of an offline conversation. But remember, the more ties you have to a place, that generally the more of a resident you're going to be, right?
Yes, you need the green card, I would think. I mean, it's not just the intent, but you have to have the green card.
Right, right,
Yeah.
right, right.
Okay. Here's another one from Jorge. Are non-residents allowed to form a trust in the U.S. to protect assets under the $60,000 exemption?
Uh, yeah, I mean, I haven't seen, and I'd have to look at that a little closer, but I mean, anybody can form a trust. Now, what kind of tax implications that's going to have back home, and even with us, remember that if you're not a U.S. person, right, and you don't have, and you don't meet the 183-day rule, but you're owning real estate, and now you have a trust here, you're adding to some of those factors where you may be a U.S. person, and why don't you want to be a U.S. person? Well, then your worldwide income gets taxed. So that's there's a lot of factors to look at here. You don't want don't, and this is obviously the saying, right? Don't let the tax tail wag the dog here.
And then Madeline says, could the filing of a probate of a will trigger penalties for failure to file FATCA and FBAR returns or schedules?
Well, I mean, there is that possibility, but you want to look at, what the asset was worth. I mean, a lot of times you have a holding that, I mean, honestly, you have no idea what it's worth, right? It just sits there. You may have, again, real estate that's highly appreciated where you cross that threshold. And I think as long as, it's a longer conversation again, but if a lot of this requires not just intent, but actual knowledge. And, if honestly, you had no idea you bought this parcel, you bought this beachfront property in wherever county for $1,000 in 1990. I mean, who knows what it's worth now, right? Until you go and you actually sell it, right? What are we looking at? And just keeping everything up to date. But if things are a mess, I mean, things are a mess. Right?
Okay, very good. Well, that answers all the questions. I think, Luis, you did such a good job. You answered most of the questions that people would have. That was the very, very interesting presentation. If you'd ever like to do this again in Spanish, I don't speak Spanish, but it would seem to me that it would be useful for people from South and Central America to have a Spanish-based webinar that they could watch to understand the U.S. estate planning system. If you'd ever like to work on that, just let us know.
Oh, definitely. It's that's been one of my missions here. It's one of the ways that I try and, let's call it, give back to my community, is to make sure that everybody has an understanding of our process, of their process, and how everything interacts. Because at the end of the day, you don't want to get lost in some confusion caused by a lack of a word here or a lack of a word there. So
Absolutely.
we'll be in touch.
Okay, well, thank you, everybody. We welcome your questions, comments, or suggestions. Luis, do you want to just give them your email address one last time before we sign off?
Sure. So my email is lsilva at leachtishman.com. And I believe the presentation is going to be available. So it's actually the last slide on there.
So it's L Silva, LSILVA, at LEECHTISHMAN.com. If you have any questions, send them to Luis, and have a great day. Thank you very much. Appreciate it.
Thanks, everyone.